others against Campbell Riddell, Paterson LLP.
Yes, Mr. Harry.
In this appeal from the inner house of the Court of Session, I appear with my learned junior, Mr. Sutherland, on behalf of the pursuers and appellants. Learned friends, Mr. Johnson, Mr. McKinley, appear for the defender and the respondents. My lords, the inner house, the court below, refused a reclaiming motion on the 8th of March 2006 at the pursuer's instance. The interlocutor is that which I now bring under appeal to this court. Their lordships will find it on page 1 of the appendix and the MS page number 73. And what I invite their lordships to do is to allow this appeal to recall that interlocutor and to remit the matter back to the Court of Session to proceed as accords. Unfortunately, in light of subsequent events, that will not quite be the procedure one would perhaps otherwise normally have expected. The matter arises, as their lordships will have seen from the statements of case and the papers that have been put before them, from a preliminary proof on prescription. Preliminary proof, however, was perhaps a little unusual in that the findings, in fact, are decidedly limited in number. And in essence, as I will have to deal with when I come to the, as it were, second of the points that the inner house decided against me. They are very few indeed. My lords will have seen that the inner house feature two separate grounds for deciding against my reclaiming motion. One of them is a point taken by all three of their lordships, and it is found in the judgment issued by Lord Malcolm. The second one is one to which the other two judges, Lady Peyton and Lord Brackadale, adhered, but about which Lord Malcolm said nothing, which is a factual point, as it were, against me. With their lordships' permission, since I understand that that forms a very limited part of my learned friend's response to this case, I propose to take that at the end as a separate issue, because the real matter before their lordships, I apprehend, is the correctness or otherwise of the argument which is put forward by Lord Malcolm. The plea in law, which had been sustained by the Lord Ordinary at the preliminary proof, was to the effect that as to I had a sound case on the merits, that case was yet prescribed. Their lordships will have seen that there was a somewhat lengthy joint minute of admissions, one of which, paragraph 47, in which involves the assumption for the purposes of the preliminary proof that I have proved the averments in the 6th and 7th articles of my condescendence. The averments in connection with prescription, again, their lordships will see in the appendix, and I may shortly call them under their lordships' attention, for they are not long. I beg Lord Lordship's pardon. They're to be found in answer 8 of the pleadings. They will be found in the appendix on pages 94 to 97.
Thank you.
May I ask, would their lordships find it more helpful if I quote MS page numbers?
MS page numbers would be helpful, yes.
In that event...
167.
167.
Thank you.
And on 167,
Yep.
Between letters A and B, 3 lines on the top, it is explained and averred that on the hypothesis that the notices to quit were defective, any cause of action that the pursuers had in relation to the notices to quit has prescribed.
Yep.
The pursuer suffered loss and damage as soon as the defective notices had been served, being the 8th of November, failing which, on the date that the tenant was required to remove, namely the 10th of November 2005. and that is followed later on by reference to a letter of 10th November 2005, which is the one that Lady Peyton and Lord Brackerdale talk about. Over the page, on page 168, A to B, we are told that the pursuers, therefore, that's in virtue of the letter, knew that recourse had to be had to legal proceedings. Pursuers were aware, directly or through their agents, that proceedings would involve loss in the form of irrecoverable legal expense, which loss forms part of the pursuer's claim against the defenders in Anderson Strathern for the costs and expenses incurred by the pursuers in the land court proceedings. Such loss was not latent. And again, the same proposition appears on page 170 between letters C and E. As soon as the tenant challenged the validity of the 2004 notices to quit, the pursuers were aware that they'd suffered loss in the form of irrecoverable legal expense. The pursuers knew, or at least with reasonable diligence ought to have known, that they had suffered loss and damage as a result of the defectively drafted notices to quit more than 5 years before the date on which the summons was served on the defenders on the 17th of May 2012. The basis of the pursuers' averments about that is on MS page number 165, where the contention is advanced between A and B that the pursuers were not aware and could not with reasonable diligence have been aware that they'd suffered a loss through breach by the defenders of the implied terms of contract as hereinbefore condescended upon until the decision of the Scottish Land Court was issued on about the 24th of July 2008. As their lordships will have realised from the dates, if that were correct, it would mean that the action was in time. And that is, of course, an appeal to Section 11, subsection 3 of the Prescription and Limitation Scotland Act of 1973. Now, the legislation is to be found as the first tab in the appendix.
Yep.
The critical sections are 6 and 11. 6 has MS number 282.
Thank you.
It provides that if, after the appropriate date, an obligation to which the section applies has subsisted for a continuous period of 5 years, without any relevant claim having been made in relation to the obligation, I miss out B as having no relevance to this case, then as from the expiration of that period, the obligation shall be extinguished. I miss out the proviso, again, it has no relevance.
Thank you.
Then his their lordships will find 11 on page 284, which relates to obligations to make reparation. Subsection 1 provides that, subject to subsections 2 and 3 below, any obligation, whether arising from any enactment or from any rule of law or from or by reason or breach of any contract or promise, to make reparation for loss, injury or damage caused by an act, neglect or default, shall be regarded for the purposes of Section 6 of this Act as having become enforceable on the date when the loss, injury or damage occurred. Subsection 2 is not of immediate relevance, but relates to the situation in which there's been a continuing act, neglect, or default, and the loss has occurred before the cessation of the Act. In that event, the date of the cessation of the act, neglect, or default is substituted for the date of enforceability.
Yeah.
The significance of the date of the enforceability is taken from section 6.3 on pages 282 to 283,
Yep.
which specifies that the appropriate date shall be, in relation to obligations of a kind specified in the second schedule, a reference to the date specified in that schedule for the obligation in question, and for present purposes, in relation to an obligation of any other kind, is a reference to the date when the obligation became enforceable. I shan't trouble their lordships with the second section, but reparation obligations don't appear in it, which is why section 11 makes provision for when those obligations will be enforceable.
Right.
Of most significance for today's purposes, I would suggest to their lordships, is section 11.3, on MS 284, in relation to a case where, on the date referred to in subsection 1 above, or as the case may be, that subsection is modified by subsection 2, the creditor was not aware, and could not with reasonable diligence have become aware, that loss, injury, and damage caused as aforesaid had occurred, the said subsection 1 shall have effect, as if for reference therein to that date there had been substituted a reference to the date when the creditor first became, or could with reasonable diligence have become, so aware. I need not trouble their lordships with subsection 4, because reparation obligations are prima facie subsection 6 obligations, and it's with section 6 obligations, and it's with section 6 that their lordships are concerned in the case in hand.
Yep.
Now, in the courts below, as I say, there was a preliminary proof on the question of whether or not those averments going to prescription and the accompanying plea in law were well-founded. And the matter was heard by a Lord Ordinary, and he formed the view that the averments were indeed well-founded, and he upheld the fifth plea in law. And I beg my Lord's pardons. His reasons for so doing will be found at MS page number 97 and following, on pages paragraphs 14 and following. Now, the matter turns, unsurprisingly, very largely upon a view taken in the court of the decision a couple of years ago of this court in the Morrison and ICL Tech case. And essentially, the Lord Ordinary considered that he should apply that case as he read it, and that the consequence of his so doing was that he should find that prescription had operated and that the rights, if any there had been, of the pursuers were extinguished through the lapse of time. And he made particular reference to the judgments of Lord Neuberger at page 40, and more particularly to the judgment of Lord Reid at a number of paragraphs. And their lordships will see that from page paragraph 15, his lordship notes the two contending interpretations of the phrase caused as aforesaid in section 11, subsection 3 that had been argued over in Morrison, and the preference of the majority of this court for the view that first of the two contentions was right, and that the words caused as aforesaid were merely adjectival, and that therefore the problem which was concerned was one relating to what was termed latent damage. And his lordship held that there was not latent damage here.
Yep.
And the reason for that was that they had known that there was a loss because the losses claimed contained two things. This on page 17, that's paragraph 17 on MS 98, about 6 lines from the foot. The specification of the loss includes, amongst other things, payment of legal fees and outlays to the defenders and to other solicitors for their work in relation to invalid notices to quit, i.e., the pursuers accepted that, of course, they knew that they had paid the defenders for drafting the notices to quit in the first place, and further that they had paid other solicitors the following year, but well in advance of the 5-year date, for...
That doesn't meet the whole width of the case, does it, as pleaded? I mean, the case as pleaded is put wider. It said bluntly that if you're expecting someone to have to leave the premises by reference to a notice of quit, and the notice to quit doesn't work, that may itself be sufficient.
That is the contention, certainly, that is put in the statement of case by the respondent, and it was put in the appendices that are, I beg your pardon, attached to the opinion of the Lord Ordinary. But what the Lord Ordinary actually finds as the critical items are these critical items.
He didn't focus on the failure to leave after the notice to quit.
No, he did not. Yeah. And so I proceed, since I'm dealing ultimately with a reclaiming motion from this decision of proof, and it would be this that would have to be dealt with again in the Court of Session were I to succeed in this appeal. For obvious reasons, I concentrate on these two.
But you've also got to deal with the other point, haven't you?
I accept, of course, that his lordship is going to say to me, well, look, you know he's supposed to leave on a given date, and that's a loss in itself. To which my reply is, well, with respect, Lord, it's not, because in the circumstances of an agricultural holdings case, in contrast to Dunlop and McGowan's, of which understandably my learned friend in his case makes not a little, this was not a case where the notice had been served too late, as had happened in McGowan's, so that anyone could see that the notice was damned from the word go in McGowan's. Not so in this case. In this case, there was an argument as to whether or not the notices were valid or not. Indeed, one of the notices succeeded. There was only 2 out of the 3 notices that were knocked down in the Scottish Land Court. And the pursuers contend, on the facts, that they had reason to believe that the notices were perfectly okay because they were being told that.
But in law they weren't. But in law they weren't. I mean, if you get a property which has a legal defect, that's a loss, isn't it? And presumably, if you have a notice to quit which is in fact invalid, that might be said to be analogous, might it?
Yes, I'm sure my learned friend Mr. Johnson will say just that. And the response I will offer back to that is to say that there's something of a difference between having a house or a property which you have no legal title to, or you have a defect to which you have a defective legal title, because you've always acquired something, and you can see with hindsight, ultimately, that you have a loss. However, it may be a long way from being clear in either of those cases at the time concerned that you are in any such position at all.
Yep.
And the whole purpose of Section 11 and of Section 6 is to secure that people get on with suing claims so that they do not become stale. And their 11 is to do with determining a date at which the pursuer, in a case, ought to get on into looking into whether or not he's got a case or not. And he can only do that, as I say, once he has either actual knowledge of the fact that he's suffered a detriment, i.e. that his title that he thought was perfectly good isn't, or that in the exercise of reasonable diligence, which he's failed on assumption to exercise, he could have found that out.
Yep.
And I say that if you look at those tests have to be applied at given dates. First of all, the date of actual concurrence and damnation, with the benefit of hindsight that we can now see. And secondly, as at the dates which are all the various dates up to the day before, 5 years before he sues by serving his action. The simplest thing to do is simply to take the day before he serves his action and say, on that date, does he in point of fact know that he suffered a detriment? And if the answer to that question is no, next question, does he on that date have knowledge of matters which mean that in the exercise of reasonable diligence, he could have found that out, and it's his fault that he hasn't, i.e., you're trying to find a date when, as if one will, one can criticise the pursuer for not getting on with it. And in that context, where one is looking to the elapse of time, destroying rights which otherwise would have been possessed, then it is my submission that the law does not require you to say that there is a loss simply because, with the benefit of hindsight, X years later, it can be ascertained that there was a loss, and that he knew about the facts which, as it happens, gave rise to that. But that does not mean that he knew, or even that in the exercise of reasonable diligence, he could have become aware that he had suffered a detriment. And my submission is that the word loss, injury, or damage, depending on which of them one's using as being the more apposite to the particular circumstances of the case in hand, presupposes that the pursuer is in a position where he actually knows he's got a detriment, or constructively he knows he's got a detriment. And I apologise for being long-winded. Ultimately, my answer to my Lord Mance's question is that in the case of both the present kind of case and the property which you get subject to a defect in title, is that no, a lay pursuer, for example, who'll know nothing of the intricacies of conveyancing, may well have absolutely no reason for many years to believe that there's anything wrong with his title, even though the lawyers would say ex post facto that there had been from the word go.
Sorry.
Well, I was just going to remark that one would have thought that anyone who is in this sort of line of operations would realise that notices to quit normally take effect, and if they don't, and the tenant is resisting quitting, then that's a fair indication that something has gone wrong. You know what I mean? The fact that ultimately the land court may decide whether or not the notice to quit was good in law isn't definitive of whether there was negligence or not on the part of a solicitor. If a solicitor, drafting these things isn't rocket science. If the solicitor's doing his job properly, then these matters don't normally end up in the Scottish Land Court.
Well, my Lord, with respect, I would submit that there appears to be a bit of a disagreement of fact. I don't claim to be a great expert in this area, so I don't particularly want to stand here and give evidence, but I understand from those who know a great deal more about it that it is far from uncommon to have the situation in which, just through sheer intransigence, or because they're busy to secure some commercial point or whatever, persons who are in receipt of perfectly good and valid notices to quit do not move because they're securing negotiating positions or whatever they're doing. Therefore, it doesn't tell you that you've lost anything, because the law says you must go to court to get a land court decree of removing in any case. So simply because you now know I've got in a fight doesn't tell you you've got a loss.
I see that's a possibility, but here you don't have the solicitors saying, for some inexplicable reason, this tenant is an awkward customer who is simply refusing to shift. They say, well, there's a problem here, and you ought to take independent advice, including about the way we've dealt with the case.
With respect, my Lord, that is the point that is taken by Lady Paterson and Lord Brackadale, and which I submit is in fact mistaken, and they have misapprehended the effect of some evidence on which the Lord Ordinary made no findings in fact. And unluckily, there is a coincidence of dates which causes Lady Paterson and Lord Brackadale to make the line of reasoning that my Lord has just figured to me, and which unfortunately is misplaced, because at least on this side of the bar, it is said that the factual position is that there had been a string of mistakes over a number of years, and that the letter of the 10th of November 2005 is about earlier mistakes. And the giveaway is that the earlier mistakes are made by a man called Max, whereas we find from the letters that the notices we are talking about were served by a lady called Fiona. Right. And that unfortunately things have been conflated. So we don't have a situation in which the solicitor has been saying, we may have made a mess of your 2004 notices and should go elsewhere. Because had that been the position, my Lord, I doubt we should be standing here.
Do we find anything about this in the Lord Ordinary's opinion?
No, we don't. It's one of the problems.
I suppose it can be said that one would have expected him to have taken the point that occurred to two members of the inner house if it had been a good point.
Yes.
Because on the face of it, it's a pretty telling point if it did refer to this advice, these notices. Absolutely.
I did not say flippantly to his lordship that I did not imagine I should be standing here before 5 justices of the Supreme Court of the United Kingdom if that was the position.
So you're only concerned with the notices served on the 8th of November 2004?
Yes.
And you say the letter is talking, you say, about the 2003 notices?
and indeed possibly even about another issue before even that. About whether
There was
it became
the other issue that tacit relocation had given rise to rights under the Agricultural Holdings Act,
which previously didn't exist.
while previously there had simply been grazing lets,
Correct.
which did not give rise to those rights.
That is the contention, at least on this side of the bar.
Yes.
And for today's purposes, I say that may be right, that may be wrong, but the Lord Ordinary has not made findings in fact about this. All the Lord Ordinary does, in order that I should give my Lord Newberger in particular the full picture about this, is that on paragraph 19 on MS page number 99 to 100, he says, according to evidence which I accept, by letter dated 10th November 2004, the defenders advised the pursuers to consult other solicitors, and the other solicitors were in place by 8th December. He says nothing about why that was, because he's not interested in why that was. He's interested in the point that you're then going to be able to say the bill had been incurred by December 2005.
So by implication, that supports what you're saying, otherwise
Yes,
it sticks out like a sore thumb, the point made by Lord Reid.
correct.
Yes.
And
I see that.
so my position shortly about that is that's about something different, and therefore
So the only point that can be made is that they'd made such a mess of other things that this should have been noticed, that these notices may have gone wrong too. But that's not really a
perhaps you
fair...
should have lost confidence earlier, might be the allegation.
Yes, I see, thank you.
So
It's also the case, isn't it, that the letter of the 10th of November refers to a telephone conversation on the 8th.
indeed,
And I think I'm right in saying that the notices, the 2004 notices, only expired on the 10th of November.
correct. It also
It's hardly likely to be referring to some defect in the notices expiring on the 10th of November.
It also says on MS 205, second full paragraph, it begins, when I wrote to you rather extensively on this matter last year, which again would not be something I would
Yes, I understand.
suggest, which would be consistent with it being about the 2004.
Okay,
Yeah.
well, I see that, thank you.
So, if I may, my lords, we return to MS 98, and the Lord Ordinary is focusing in on the fees that were paid both to Campbell Riddell in the first instance, and then to Anderson Strathern for the work in the land court. And he notices these, and also, I should say, in fairness, he talks about a loss of a benefit of immediate uplift in £200,000, though, as their lordships will see in a moment, he actually makes no finding about that. What he does find established...
Wait a minute, that's an allegation by the pursuers, so he's entitled to take it, isn't he, as a starting point?
Yes. Absolutely. But what we find happens is that he says that on paragraph 19, MS 99,
Yep.
that there's the 200,000 uplift, and then there's the fees and outlays for services provided by the pursuers and other solicitors not incurred but for the breach. Then there's the passage I've called to their lordship's attention already. Any fees incurred by the pursuers for fees rendered would not be incurred but for the breach of contract were incurred before 8th December. At the latest, I hold it proved that the pursuers suffered loss caused by the defender's breach of contract by no later than 10th November 2005.
Yep.
That's because they've told us to depart, so any liability we have to pay them fees must already be incurred by the 10th of November.
Well, that means that it's not the actual incurring of the fees which he's relying on. He must be relying on the fact that possession can't be obtained on 10th of November 2005 or wasn't obtainable, and or the fact that as a result the property is alleged to have fallen or lost value of 200,000. That's all that could have happened on the 10th of November.
No, my lord, with respect, I would submit that what he's saying is, because they have resigned by the 10th of November, it follows that any fees incurred, and therefore the loss which they represent, have been caused by no later than the 10th of November. The passage which follows says...
Oh, I see. You mean it's the earlier fees, is it? Are we talking about fees?
There are two sets here. There's a set incurred to the defenders. That's the set for drafting the notices to quit in the first place, and the work they do down to the date they resign on the 10th of November. There is then a second set, because they having resigned, the pursuers go off to another firm of solicitors, Anderson Strathern, and they take up the reins and they conduct the proceedings, they recommend and pursue the proceedings that follow in the land court. And they, of course, have to be paid for that. And so there are fees which are the Campbell Riddell fees incurred by the 10th of November, and then there are fees incurred to Anderson Strathern, as His Lordship's going to hold, between December 2005 and February 2006. So they're both quite sufficient in date to put me into loss of rights through prescription.
But it can't be the latter fees that he's referring to, or he's relying on, because he's found loss as suffered before Anderson Strathern was ever instructed.
In paragraph 19, he's talking about the Campbell Riddell fees.
He isn't, is he?
But the 10th November presumably relates, insofar as it is addressing the failure of the land to obtain an enhanced value, that is relating to the date on which the tenant failed to move.
Mm-hmm.
Indeed, my lord. I'm going to come back to the what the immediate uplift averment says in a moment. But His Lordship's interest here is, as I suggest, in saying 10th November is the date they resigned. Therefore, any fees incurred to Campbell Riddell was a loss which had happened, as he says.
They weren't incurred by reason of the breach. They were, at least not in any ordinary sense.
Well, those are the fees.
Because there's a choice as to how to put your damages. If you're putting them on costs thrown away, then they might be recoverable, but they're not. They're putting them on loss suffered by reason of the breach, and they can't say that they incurred the original legal fees during the course of which negligent advice was given by reason of the negligence.
No, what they are.
I mean, it's a bit. Maybe it's a bit odd, this passage, but.
Well, howsoever that may be, we certainly come down on 21. We have by then got a situation in which, as His Lordship says, 3 lines into 21, I agree with senior counsel for the defender that it is not relevant that the pursuer may not have regarded legal expenses as a loss until that time. That introduces a subjective consideration which has no place in the application of 11.3. The pursuer's offer to prove that their loss included payment of money to their solicitors. The commencement of the prescriptive period was triggered when the pursuers became liable for fees and outlays, and they were aware they were so liable, not when they were aware that they'd suffered a compensatable loss in the reparation sense. Now there, the Lord Ordinary moves into the area of actionability, as it were, which had been the subject matter of Morrison, but that is not the contention that the pursuers are advancing in this case. We do not say that it is necessary that to know that you have a loss, that you should know that it is the proper subject of compensation.
No.
And so the pre-Morrison understanding of the law to which the Lord Ordinary refers is not actually material. But for present purposes, his Lordship goes on at the end of 21 to say it's a matter of agreement that by 17th February 2006 at the latest, the pursuers had incurred material expense in relation to the land court applications. There can be no suggestion that pursuers were unaware of having incurred such expense at the time it was incurred. They paid the bills. The pursuer's obligation to meet their solicitor's fees and outlays was not latent damage. 22. I'm conscious I've made no finding on the question whether the pursuers were or could with reasonable diligence have become aware before 17th May that they'd incurred a loss on 10th November 2005 by way of a diminution in the value of the land. there was neither evidence nor argument directed specifically to that point, since the onus of establishing lack of awareness, actual or constructive
Yeah,
labour.
we've read that, yeah.
We've read that. Certainly.
Very well.
And he rests his decision on actual knowledge that we'd paid
Yeah,
fees.
we've seen that, yeah.
When the matter goes into the inner house, that is the focus of the case. And their lordships will find on MS 75 and following the opinion of Lady Peyton. Now, that's very largely taken up with the point I have already discussed with their lordships about the mistake.
Thank you.
And all that matters from that is that she, like Lord Brackadale on MS 78, agrees with Lord Malcolm, whose opinion starts on MS 79. And he sets out what the complaint is, that the case of 2 of the notices have failed because they have got defects in them, and that almost 4 years after the Land Court case, the present action was raised, and they seek damages on account of the breach of contract in drafting ineffective notices to quit. The defenders don't concede the merits of the case, but they plead prescription under Section 6. Particular reliance is placed on the fact that the heads of loss include legal fees paid to the defenders well before 2007 in respect to the Land Court proceedings. His Lordship refers the fees to the defenders, but I suspect he means the defenders and Anderson Strathdee. His Lordship narrates the submissions, and in particular the contention on this side of the bar, which their Lordships have read in the stated case, namely that we did not know and could not have known that we had a loss. And the case against me is founded on Morrison, and was founded on Morrison there. In paragraph 12, his Lordship makes what I submit is a not unimportant point, that in Morrison the fact of loss was obvious. It involved damage to a building caused by an explosion of neighbouring property. Now, he then goes on at the foot of that page to say, it may not be immediately ascertainable costs being incurred by an act of omission, which amount to legal wrong. Does that mean that in terms of Section 11.3, the commencement of the prescriptive period is postponed? His Lordship then goes on to look at what would have been the law before Morrison, and he looks at the law in Morrison. At 15, down at the foot of 82, he's talking about what is meant by the discovery of loss and damage. Does the prescriptive period begin when the pursuers knew they'd incurred a liability and fees to solicitors, or was it postponed until they were aware or should have been aware of the background facts which demonstrate the costs may be recoverable from the solicitors? Can it be said that only then were the pursuers actively or constructively aware of having suffered loss, injury or damage? An affirmative answer to that question is not easy to reconcile with the approach adopted by the majority of the justices in Morrison, an approach which appears to rule out any inquiry as to whether the pursuers were ignorant of or on notice as to the cause of the claimed loss. The Lord Ordinary upheld the prescription plea on a narrow and precise basis, and he refers to paragraphs 20 and 21. On the strength of Morrison, he held it would not be relevant to prove that till the Land Court decision, the pursuers could not have regarded the expenses as a loss, because that would be introducing subjective considerations. The obligation to pay bills was not latent damage, and the prescriptive period began when the pursuers knew they'd incurred a liability, not when they had become aware that they'd sustained a compensatable loss in the reparation sense. As I've said already, that's not actually the case that's being made. The Lord Ordinary's decision, he says in the last sentence, rested solely on the pursuer's knowledge that legal fees were being incurred. The court then goes on to discuss the decision in Morrison and said there's no direct consideration in Morrison, because of course it was obvious that there was a loss, but the knowledge of the cause of the event is said to be relevant to awareness that one has suffered something which can be identified as loss, injury and damage within the meaning of the statute provision. The emphasis was on the words caused as aforesaid. However, the justices explained in detail the correct overall approach to Section 11, subsection 3. The view was it would make sense to postpone the prescriptive period when the creditor is not and has no reason to be aware that he has suffered loss.
Well, we have read these opinions.
Lord.
Yeah.
So the basis on which the decision is taken against me is that the court conceives that on the basis of Morrison, it is obliged loyally to follow that decision,
Yeah.
and that means that this is not latent damage for the purposes of Morrison, and that there is no basis on which it can be said that I am entitled to claim that because I do not know and have no reason to believe that I've suffered a loss, that allows me to defer under 11.3 the time concerned. They follow two grounds. One is the long ground on Morrison in relation to actionability, and the second, the rejection of the minority view that cause, as aforesaid, meant cause as an act or omission. On MS 87, their lordships will notice that there appears to be a degree of discomfort about doing this. In paragraph 23, his lordship suggested that a fourth reason for minority view might have been added, that there may have been occasions when knowledge of the cause is necessary for awareness that loss has been occurred. And then in paragraph 24, in somewhat elegant terms, he says, it's our duty loyally to follow what the justices have laid down. The question whether they meant something other than the inner house has read them as meaning, being a matter for their lordships to hold a view on, and that one of the problems of the view that as it's read by the inner house, giving preference to certainty, is that it comes with the creation of hard cases, and that the current action suggests that these cases may be more common than was anticipated. My lords, I submit to their lordships that that last sentence is probably correct. There have been a number of cases in the Court of Session, at least, which have been assisted waiting for the outcome of this, and a number of cases which have not and have been decided on it. And there are, at least at the anecdotal level, not a few cases where people say, what are we to do now? How could we possibly have worked out that we had a loss? And there are unhappy clients. Not that that is
It's a bit that's a bit surprising, isn't it? I mean, you've got 5 years to work out whether you may have a claim if tenants haven't left when solicitors have served or lawyers have served notice to quit. Anyway, to suggest that the sky's going to fall in if the 5-layer limitation basis period runs on the basis held in the courts below seems to me a bit surprising.
well, my lord. My lord will be aware that historically Morrison overturned.
Yes, well, that's what I wondered, whether residual thinking was playing a part. But anyway, leave that aside.
I couldn't answer that question.
Morrison is now...
Well, put very simply, your case distinguishes between two circumstances. If I have a garden wall and it falls down, I know something has gone awry. And you say that from that moment, from the fall of the garden wall, time is ticking against me. One hears a clock ticking, to use a current phrase. The second circumstance is I purchase a fan to cope with the hot weather in London, but then the weather changes and I leave it in its box for a considerable period of time. Several years later, I take it out of its box and I discover it doesn't work. You say 11.3 allows the time to start running when I take it out of the box, not till then.
Yes,
The fact that I spent the money on a Duff fan earlier is neither here nor there.
yes, Maud. That's what I say.
Yeah.
And
I mean, the lesson to that is surely most people do try things out fairly shortly after purchasing them. So still,
That may be an answer, but I just wanted to...
I realise
submission as I see it.
Things are quite likely to seize up after 7 years, as I found.
Is it an objective or a subjective test? Is it if the wall falls down in a house, on the garden of a house I own, but I'm not there and the place is empty? Does that make any difference on your case? In other words, do I have to know that the wall has fallen down?
Well, it's reasonable diligence.
Diligence. I was
Subjective
about to say the
test.
reasonable diligence will be the issue.
It's an objective test. So where does that leave Lord Hodges' fan?
Lord Hodges' fan is probably a question of whether or not one thinks that, along with my Lord Mance, my Lord Hodge was under an obligation to go and open and check his
Not an
fan
obligation,
earlier.
but there may be some downside if you don't.
Yeah,
Reasonable
sorry,
diligence.
the word obligation
Equally,
takes place.
well, equally, it could be said if you don't inspect your property.
Yes.
I mean, there is an element of repose about statutes of prescription. They're intended to they intended to enable people to close their affairs, and if people choose to have work done on property which they don't then look at, I mean, firstly, one would say they were mad, and secondly, one isn't very sympathetic with an idea that they should be entitled to come back 6 years later and say, I've got a claim. The first thing you do after you've got work done on property is inspect it.
That may be so, and that may afford a reason for saying that in certain circumstances one is in a position where, had reasonable diligence but been exercised, you would indeed know. And therefore,
We have to, I mean, in order to decide prescription issues on your analysis, we have to try negligence actions.
in order to no, with respect, I don't say that. What I say is that in order to be in a position to set the time running under Section 11.3, you need to be able to say that, at the very lowest, in the exercise of reasonable diligence, you could have discovered that you had a loss, i.e., that you have suffered some form of detriment. The problem arises in cases of which the instant is, I suggest, an example, in which, for perfectly good reasons, as Lord Malcolm accepted, it's part of his phraseology, one does not know, and is not to be expected to have known, that something means that you have spent money you shouldn't, have thrown money away, have paid too much, or you've suffered some form of damage, which is as much latent in the sense that it is hidden from your eyes as is the problem in the design of the building, which is structurally eating away at it, which is the classical example which has always been used for Section 11.3 as being the latent damage. And the submission which is made in this case is that before one can say that time is to start running, one has to be able to say that the pursuer knows he suffered a loss, not that he's paid some bills or that he's incurred a cost. One has to be able to say that he's actually sustained a detriment, which means that one is entitled to expect him to start to make some gentle inquiries and perhaps less gentle inquiries as to the cause of that and whether or not it is a cause which gives him a right to recover from the defender. This, after all, is a piece of legislation which is concerned with saying that if too much time passes, the rights that you had will be extinguished.
So say for example, Lord Hodge buys his fan and takes it home and switches it on, and it works perfectly well. A week later, it stops working because the motor has burned out. And that's because of a defect in its manufacture. Presumably you would say that although he suffers the loss when he hands over the £20 for the fan, he doesn't and can't, with reasonable diligence, know that he's suffered that loss until it stops working a week later.
Yes, I say that the test in 11.3 is one which says, what should the person in the position of the pursuer who's done what he's done or not done what he's done, which is a reasonable diligence, if he is, on the basis of that, either actually or constructively aware that he has suffered a detriment, he's lighter in the pocket, he's had his property rights damaged, whatever, he's worse off than he should be in some paradigm world where everything goes swimmingly. Then time starts to count, but not until then, because what we are interested in doing is establishing a balance of interests between A, the certainty in closing the book, as my Lord Mans puts it, and equally securing that we don't produce a situation of unfairnesses where, in the extreme cases, people can find that they're prescribed before they know they've got a problem, which is the very injustice to which Section 11.3 is directed to the prevention.
But in this case, you knew you had a problem.
Well, my Lord, I say that
Sorry?
I say that I did not know that I had a problem. In truth, of course, ultimately we know with hindsight there were all sorts of things wrong and all sorts of losses, which is why there is an action in court. However, when one is looking to 11.3, one does not judge it on the basis of what one knows now and what one can see now, or even what one can see now of what the position in truth was long ago. One has to judge it as the position as it appeared as at, let us say, the day before 5 years would elapse.
Well, presumably your clients were pretty annoyed. These were properties they wanted for development. They were unable to get vacant possession. They've pleaded, and I think there's a slight inconsistency in the Lord Ordinary's judgment between paragraphs 19 and 22, because in 22 he says that wasn't, I think perhaps in 22 he's devoting himself to awareness of the diminution in value. But in 19, he says, according to the pursuers of averments which are to be taken to be established, the value of the fields would have increased by 200,000. I mean, I would take a great deal of persuading that it wasn't absolutely obvious, since you wanted this for development, and that pretty soon, if not immediately, on the 10th of November 2005, that you'd suffered a potential loss in the value of the fields, because if you want them for development, they presumably that's presumably because they're more valuable, and you have pleaded that the value was pretty large, increase in value was pretty large. It seems to me a bit odd that you've got to deal with this, haven't you? I mean, it's raised against you.
Yeah. Well, since my Lord raises the point now, it seems...
everything's in the arena, as I understand it, or are you suggesting the contrary, that we are only obliged to focus on the fees?
Well, my learned friend puts in his statement of case, he says, look, there might have been an uplift in value which was missing.
No, you have alleged, and that is to be taken as established, that the value would have increased by 200,000. That's what the Lord Ordinary says.
And the allegation that is made is on MS 151. And it says, had the defenders drafted valid notices to quit, the pursuers would have been successful in respect of their applications, would have recovered possession of the 50-acre field and 40-acre field free of secure agricultural tenancy, and the Agricultural Holdings Act 1991. That would have happened, my Lord, whenever the Land Court said, here is your decree of removing. Had the 40-acre field and 50-acre field been free of secure tenancy under the Agricultural Holdings Act, they would have been able to fully exploit the development potential of the site without any restrictions. They would have benefited from an immediate uplift in the value of the field of £200,000. Now, my Lord, as I understand it, that's talking about an immediate uplift in the value of the fields in the event that I get the man out, i.e. it's something that happens on a magic day in 2008.
No, it's had they drafted valid notices of quit, they would have been successful, I see, in their applications and would have recovered possession. So you say it's all much later.
Yes.
Well, that postulates that the tenants would have remained even if the notices had been persevered, even if the notices had been valid, I suppose, yes.
Yes, my Lord. That's what's been contended.
In Scots law, could you have excluded them? If the notices to quit had been valid, could you have excluded them physically, as it were, once the notice is expired, or did you have to go to court?
No, you must go to court.
If it's contested, yes.
Yeah.
Yes.
I see.
To remove him, I must have a court decree, even if the notices are absolutely perfect and the tenancy is ended, as was demonstrated by the field in the middle, because, as I say, 1 out of 3 succeeded
Yes,
to
the
it.
curiosity is here that your point really is they're refusing to go. The fact you didn't get possession when the notices expired at the time was attributable to them not going.
Yeah.
Yes.
Not to the notices to quit not being valid.
Well, as far as we knew. Yeah.
As far as you knew.
Yeah.
I mean, tenants I don't know what happens north of the border, but south of the border, tenants don't always vacate pursuant to a valid notice to quit.
I'm told the same thing happens in the north, my lord.
So you say that it's only once the court rules against you that you can say that this occurred as a result of your notices to quit being invalid.
Yes.
Otherwise, it was perfectly consistent with the tenants not vacating because they chose not to vacate.
Yes, because they hoped to benefit commercially from not doing so.
So if we take Lord Hodges' fan and you're taking it home and somebody negligently knocks into you and you drop it, so when you discover it doesn't work, you can't be sure whether it's because of the person knocking into you or
Because I
because
dropped
of
it.
the it was defective when it was sold. Does that make any difference? If it turns out that once you get a plumber or electrician more likely to look at it, he tells you that it's due to a defect in the manufacture rather than because it was dropped.
If we're taking these as sort of broad examples, because obviously in the case of the fan, one would rather worry about certain statutory alterations, but we treat these as examples.
We're not looking at it in understanding,
Then
of course.
my submission would be, no, until you're in a position in which you either actually know or in the exercise of reasonable diligence constructively know that you have suffered a loss, i.e.
If you
there's
know the
something wrong
fan,
with it.
do you date it in the example I've given? Do you date the time running from the date on which you discover the fan doesn't work, or from the date on which the electrician you call to repair it tells you this was due to a defect in manufacture, not to the fact that you dropped it?
I would suggest the answer would be that you have a loss from when the fan doesn't work.
Right.
And you count time from then, because
that
the
must be
second
so.
question
Yeah, well,
is, do I have a right of action?
Well,
and that's what, and I'm not challenging, Morrison says,
Well,
you lost that last time, Mr.
This is the reason I ask is it does seem to me you're right to accept that. Can't it be said in this case, your notice to quit expires, the tenants don't go, either because they want to stay as long as they can or because the notice to quit is bad? Isn't that a bit like Lord Hodges' fan being dropped en route to being taken home?
Well,
Two possible causes.
there are two possible causes, but the assumption in normal work when you employ professionals, I would submit, is that what you get is good and proper work.
Well, the assumption when you buy a fan is you're going to have a fan that works. Same point.
Indeed so, but it is considerably more complex and more difficult in this case to deal with the question of what doesn't work as opposed to the non-working fan. Matters are complicated here by the fact that, again, and we're somewhat hampered by absence of factual findings in this connection, but it is said on this side of the bar that there was reason to believe that the problem was the intransigence rather than any error in the notices to quit, because they were told the notices to quit were perfectly good. And they were told that, not by the defenders, but by the second firm of solicitors. That, after all, is why they recommended that you go ahead into the land court. So in this particular case, howsoever matters might fall out of my Lord's examples, I say there was perfectly good reason for the pursuers and appellants in this case not to spot any loss at all. As far as they were concerned, they had a problem, but not a loss. They had a tenant who didn't want to get out, and they could see commercial reasons why he'd be doing that, and no reason to believe that the notices to quit are other than good, as indeed one of them was.
Yeah, so you say something may have gone awry with the removal, but you didn't know that something had gone awry with the notice to quit.
We didn't know that we had suffered any loss. All we knew was he had suffered a problem which the law says you have to put up with.
What does the test go awry? I mean, if, for example, your factory explodes in a thunderstorm, having been hit by lightning, You've suffered a loss, have you? Even if you think at the time, that was terrible bad luck, that was lightning. But then you discover years later that it actually, the reason why lightning had any effect in causing the factory to blow up was that there was some connection between the lightning conductor and your electrical system.
The answer to that, I would suggest, my lord, is that seeing a hole in the side of one's factory because of a lightning strike is, for this purpose, in no wise distinguishable from seeing a hole in the side of one's shop because the factory across the road is blown up.
Even though everyone says, all at the time, they say, that's bad luck, that lightning, and so on. So there are some situations in which you suffer a loss, even though time is actually running, because you don't have to know that it's due to anyone's fault under Morrison.
Yeah.
You don't, no.
Yeah. I mean, it's the same as my garden wall example.
Yeah.
I mean, there may be all sorts of reasons why a garden wall falls down, but in your position, once it's fallen down, the clock is ticking.
Yes.
So it seems to me that we're moving towards the idea of one rule for physical damage, another rule for financial damage, or another rule for professional negligence. When do we move from one to the other then?
Well, I'm not contending that there is a separate rule for professional negligence cases or financial damage cases, simply that those are cases in which it's more likely that you're going to see yourself running into this problem. But if His Lordship wishes me to offer him one about, well, it will be an economic loss problem because it'll be your own building, but one which would involve physical loss that I suggest demonstrates quite starkly the problem which the interpretation of Morrison, which has been followed by the Inner House, creates, is this. Let us assume that a building is defective, not by reason of any fault of construction, but by reason of defective design.
Yes.
And let us assume that it's a traditional building contract, it's not design and build.
Yes.
And therefore, the position is that the defect is one which has been lurking in the design from the outset. When that design was devised, it was put into the building warrants, it was put into the applications for building standards and so forth. In the way of these things, that takes a year or two to get through.
Yes.
And because of, let's say, some financing problem, it's another year before they start building.
Yes.
Now, if I assume that because of this design, there is a defect in this building which will show up 2.5 years after it's built, if I've done my sums correctly, the result of that will be that by the time there is any sign to investigate of this defective building, because the problem is attributable to the engineer and you paid your engineer when he did the original design work and drew your drawings, the time has run out before you know there's a problem, before maybe even the cracks are appearing. Because the first item of loss which you have suffered, which is usually the reason you have to have a physical manifestation to turn it into loss. But on this event, on this argument, the first item of loss, that is the beginning of the whole concatenation of all the repair work and everything else you had to do, was occurred way back when you paid that engineer for the defective design. Sorry, my lord.
That's not that. No, that's not the loss, is it?
No, because I mean, you have a claim against the engineer in contract. He has to put you in a position where the contract was properly fulfilled, and the measure of loss is the cost of him earning his fee, as it were.
The more common problem would be a defect in the title to the property you buy. Many people will tend to own their property for more than 5 years.
Yeah. Yes.
So you normally wouldn't discover it.
Yes.
Which is, certainly it's a problem that is familiar in English law. But
well, their lordships will recall one of the cases they considered in Morrison was a case of exactly that, Glasper and Roger, where they didn't know that there was anything wrong, that the title was in the wrong name. They knew nothing about it until they tried to sell it however many years later it was.
there have been problems.
And it would be unsurprising to find that kind of problem only comes to your attention when you try to sell your house 10 years later.
The problem is that what we're concerned with here, it does seem very unfair, I agree, but the problem we're concerned with, identified by Lord Mance, is that, well, it can work unfairly for pursuers. It also is right that people in business and other potential defenders are able to draw a line and know that, and conduct their affairs knowing that they're safe from being sued because of prescription. And whenever you have any rules, there will inevitably be individual cases where it can seem to work unfairly. But it could be said against you that if we start tinkering with what may be a clear, some may think an unfair principle laid down in a previous decision, then we lead the law into confusion. It should be for the legislature to consider whether the law is working satisfactorily, rather than for us to try and tweak the law so we get potentially inconsistent decisions and areas of greater uncertainty. Which is why I'm trying to find out exactly how you, as it were, carve this out from the Morrison case.
Well, the point that my Lord figures to me is, of course, part of the misfortune of being a Supreme Court. That's the kind of problems one gets. But
I'm not complaining.
And as to, well, the legislature may step in, of course it may. That's always possible, but when it may happen, one does not know. And the law has to be attended to in the meantime. Now, I accept, for it would be foolish to deny it, there's of course a merit in my Lord Mance's point about certainty in people being able to close their books. But this is an exercise in drawing balances between interests of two sets of people who are involved. People who may wish to be pursuers, who feel that they've been unable to discern any losses and are, as it were, knocked out before they start, and certainty on the other hand.
Sorry, I beg your pardon.
No, it's for me not to interrupt my Lord.
No, I was interrupting you, I'm sorry.
Now, if His Lordship asks me, do I say, is there a bright line that this applies in finance cases, this applies in professional negligence cases, then my reply to him is that I don't suggest that it is a bright line that applies as a special rule for finance cases, for one would say, why should the finance case be treated any differently from the case that His Lordship has figured to me of the person who doesn't find out that there was a defect in their title till they try to sell it? Why, if that loss falls on the bank because they've called up the property, is that okay? But it isn't if it falls on the householder. And those are going to be obvious objections to, these are distinctions without any sensible policy or rational distinction between them. And that is obviously to be avoided. So, my Lord, I don't contend for a separate rule for finance cases. I don't contend for a separate rule for professional negligence cases. I point out what is probably obvious, that the likelihood is that the numbers of classes of case in which this will happen will very probably fall into those sorts of areas, because they're the ones in which, understandably and forgivably, people will not know on the reasonable diligence test whether or not they're faced up with a loss, whereas the one where you suddenly find that there's a hole where your shop used to be, as was instantly admitted in Morrison, there is a clear and immediate knowledge of loss evident to anyone. And in the physical case, simply because it is physical, it's going to be more likely to see that you have a problem with the item concerned. So I regret that I don't offer any straightforward and simple solutions about it's this class of case or that class of case. And I acknowledge that in anything which involves the drawing of lines and taking balances, there may well be hard cases, which is why it's the fact that the court is coming and telling one that the number of hard cases seem to be just a little too many, as far as they can see, which causes one to say, well, is that actually correct, or is that because the Inner House has misapprehended what their lordships are seeking to lay down, and that the solution to this is to say, what is a loss? And you look at the ordinary English meanings of loss and injury and damage, and you say, when is it that he ought, in the exercise of reasonable diligence, to be able to ascertain he's got a loss? If, for example, the householder or the property owner realizes, here are cracks up in the wall, there are sinister cracks and there are cracks which are comparatively innocent. Which are they? I'm not qualified to know. So he does the sensible thing and he goes and asks some engineers, please have a look at it. And he gives all the engineers all the things they ask for and all the information they ask for, and they give him advice, and they tell him that his cracks are all right. Well, if they're not all right, he's exercised reasonable diligence, but he couldn't find out because the advice he was given was wrong. It may not be actionably wrong, there may be no complaint about it, but it's just wrong. In which case, once again faced with the issue of how does he know that he's actually got a loss because he's been told it's all right, it's just settlement or something. And that is the kind of problem that is going to occur across the gamut of cases and can't be avoided. And what I invite their lordships to do is to say a way out of these problems, or at least to reduce their number, which may be the most that their lordships can do, is, as I put it in my statement of case, to apply the ordinary English usages of these terms and to say, when is it that you appreciate that you have a detriment, as opposed to finding that you're told that time ran against you and your rights were extinguished before ever anyone could say that you ought even to have known that you had them, or to have even looked to find out if you had them. And that is essentially what I face the court up with in this particular case, and that it forms an example of a genus which I say merits the attention of this court. Whether or not any legislature may subsequently attend to it is in the future. It's fair to say that on Friday last there came out a report from the Scottish Law Commission about it, but that delicately does not say very much about this problem, not least because it was not unknown in the halls of the Scottish Law Commission that this case was coming here, and it might seem a little impertinent for them to start talking about it now. But I don't therefore offer a suggestion that this is financial cases or it's professional negligence cases, because I submit that that distinction isn't in truth a difference which is appropriate to the circumstances of the case. It applies as much to my Lord Neuberger's householder who doesn't find out about his title as it does to the bank.
Was the Law Commission paper a consultative memorandum or a report?
It was a report that came out. It was a report Friday.
Yeah.
Now, fairly obviously, as a matter of everyday knowledge about current political affairs, how busy legislators north and south of the border may be with other things in the future is
Yes.
open to question.
Yep.
I beg Lord's pardon. So, in essence, I put before the lordships then the notion that the balance that has to be drawn is one which ought to be drawn so as to say that loss has to be capable of being discerned as being a detriment, because if it is not, and it operates purely in hindsight, it runs the risk of being unduly unfair to pursuers, and one also wonders why it would be that the 11.3 test would exist. 11.1 has, after all, said that one has, in hindsight and knowing everything that was ultimately to be known, to be able to identify what the state of play actually was, and there was, in truth, something which was a loss.
Can I just ask, if we're pursuing your line of thoughts, the 200,000 is something which you haven't lost until your application fails. And is the same true of the costs? Because if your application succeeds, you'll recover them from the other side.
I'm indebted to my lord. It's a point I was overlooking. My position about the costs, my lord, is that given that I have to go to court, then when I am faced with my intransigent tenant, I know that I am going to have to pay lawyers to take that court case. I know that if I win that case, I will hopefully get an award of expenses. No reason to believe I won't. And however, there will be a sum left over, which will be the extrajudicial expenses, which I don't recover because they're not awarded under the Scottish rules on expenses.
But isn't it a loss having to fund the expenses in the meanwhile?
No, I submit it isn't, because
All of them?
it is... Sorry.
Yes, sorry.
It's something to which the law says I simply have to go. It's part of the bill for removing a tenant. And, of course, since you don't get expenses immediately, you get expenses in arrears, it follows that there is a funding cost lurking in that. It's just part of what you have to do.
But it's still sort of extra irritant and presumably it costs you some funding costs, probably.
But as I submit that that's not a loss, injury and damage for the purposes of Section 11 or 11.3, because 11 is about a situation in which you're preventing the loss of rights to sue to recover something. If the law says you're never allowed to recover it anyway, and that is the case of my extrajudicial expenses and the funding cost, because all that the law in Scotland allows you back is whatever the auditor says is the proper figure for your expenses, then that's not something which Section 6 could be depriving you of, and Section 11 could be a shield against the deprivation of under Section 6. Therefore, it doesn't count as loss.
I see. Well, that's... what about going back to the 200,000? You say there's no loss till your application fails, but isn't there? Because on your own analysis, you have postponed the failure to get possession has postponed the benefit of the increase in value, even if it's not immediate, on the 10th of November 2005, until after the applications are resolved. So isn't there an immediate loss there? I mean, if something would be worth £200,000 more now, that's more valuable than having it worth £200,000 more in a year.
If, however, the reason for the financing cost on that, if I can call it that, is because of the intransigence of the tenant farmer, then this is not loss caused as aforesaid, in that it does not have...
Oh, wait a minute, that's a different matter, isn't it?
But it still has to be causally related to the cause of action.
I see. Yes,
is what the majority tells me caused as aforesaid means in 11.3.
Yes, I see.
So it's only when I get to the 2008 stage and it's apparent that, no, I've got a loss now, and it's because the notices to quit are deficient, that there is any loss which is causally connected with my proposed cause of action. And I don't know that I've got any such loss until things go wrong in 2008.
Yep.
And therefore, it's the case that there isn't any kind of loss relating to costs at all. And I submit that the point that's taken against me in the statement of case for the respondents, and indeed in their pleadings, about irrecoverable losses is misplaced, because those are not losses for the purposes of Section 6 and 11, because the law never allows me to recover them anyway. And if I don't recover my expenses, which I think is the other one that my Lord Mance is putting to me, then that is presumably because of the insolvency or disappearance or whatever of the tenant farmer. It's, again, not causally related to my cause of action.
Right.
Are you able to give us a definition of of loss.
Right.
I've been thinking about it myself, and it seems to have something to do with the causation of the expenditure. If we're talking about expenditure you're talking about, or the causation of some financial detriment. We know from 11.1 that loss, injury, or damage exist as concepts separately from causation by an act, neglect, or default. And you've made it clear that you're not tying the concept of loss to the existence of some legal wrong, but you are tying it to a rather vaguely expressed idea, I think, if I may say so, about things going awry or things not being as they would be in an ideal world. I mean, there seems to be some underlying idea about how this expenditure, if it's expenditure we're discussing, has come about.
My learned friend takes me to task about the number of different variants I've offered for explanations, and I hold my hand up and plead guilty to that charge. I have offered a whole number of possibilities. But I would submit that what I have been seeking to get at here and in the court below has a core of consistency to it, which is that if one were putting it in the vernacular, one would have to say that one was the worse off, that my pockets were the lighter than they ought to be. And what I had, I believe, suggested in the court below was that on the face of it, or the weight of it, the pockets didn't seem to be any lighter, because though I had paid out from my left pocket the sum for the notices to quit, I now had those notices in my right pocket, and that, assuming that I've been rightly charged for them, I'm no worse off. I haven't suffered or lost anything. If we talk about losing something, we mean that we have got the opposite of a gain, a disbenefit. Mm-hmm. In the famous music hall joke, the only thing you can lose without ever having it in the first place is your way home. And if we ignore that kind of thing, what one is directed to, and I'm happy to be told by others that they can devise more precise or better definitions of what is at hand, is the conception that you have to appreciate that you have suffered a detriment, the opposite of a gain, as I put it, lifting it from the dictionaries. Mm-hmm. And that yesterday I was better off than I am today is what you have to appreciate.
Okay.
And that I'm the poorer, if I may put it like that. I'm simply adding to the list that I've offered. And as I say, others may be able to do a better job, but I submit that what I'm trying to get across is clear enough.
I've got your point about the tenants in transience, but actually, that causes you a loss, does it? I mean, if your tenant doesn't get out, your immediate reaction is, I would have been 200,000 better off if he'd got out today. I've suffered a loss. Now, of course, if that's the only fact, then there's no question of prescription, because unless there's a claim against the tenant for damages. But the reality is that we know that the tenant had a right not to get out, so it's a bit difficult to attribute your loss to the tenant, and there will be no question of prescription against them. Why can't your loss be attributed there to the deficiency in the notice? I think your case says, oh well, tenants are intransigent, but even if one takes that into account, are they always intransigent? Do they always breach their obligations and refuse to leave?
I'm sure they don't.
A slightly odd position if they were wrong, if the tenant's wrong in refusing to leave, then you've suffered a loss due to the tenant's breach. If the tenant's right in refusing to leave, why can't you say you've suffered a loss due to the deficiency in the notice?
Because
I mean, looking at it certainly now, afterwards, and your only answer to that is to try to feed in knowledge, which seems to me knowledge actually of fault, which is what Morrison says you can't feed in.
that is certainly what Morrison says one can't feed in, and while obviously the view that their lordships take of it is a matter for them, my contention is I'm not doing that. What I'm doing is I'm saying I've got to be to apprehend that I am the worse off, and that worse off has to be causally related to what turns out to be, in the end, my cause of
What
action.
about my Morton's fault? I mean, if it is the tenant's fault, right, the tenant should have left, then you've suffered a loss. You know once, don't you? And if it isn't, then it's if the tenants are justified, then it must be somebody else's.
Well, my submission is that I nip out of the way of each of the times, because I see the solution to that is that if the tenant is wrong and I have a claim against the tenant, that's all very interesting, but that's not loss caused as aforesaid, which is what loss, injury and damage caused as aforesaid. That may or may not be a good claim against the tenant.
If the tenant was wrong, then the limitation as regards the tenant would run from the date of the tenant refusing to leave.
Well, if you have got the tenant refusing to leave and he's in the wrong, so you've got an action against him, you would be on the catch that on the hypothesis we're looking at, you will believe that you are the worse off, and you will think you know that you are the worse off. So at the time, you would be saying that you would be having to look into the question on reasonable diligence would start you running on the tenant. But the problem would be that doubtless when you did that, the question would arise as to whether or not actually it was the fault of the solicitor. So you would end up in the same situation of actually not knowing, or in the exercise of being able to, diligence being able to do so, because you're taking in the reasonable diligence will actually raise doubt, not...
Right.
But that does mean that you are introducing questions of awareness or lack of awareness as to who is at fault.
I am looking at...
You totally know which one's at fault, and your limitation doesn't run.
I am looking at the question in relation to each of the people as my Lord asks me to do. And in each case, I am obliged to go and say, am I aware that that I have suffered a loss, which is causally connected with my hypothetical future right of action? So I say, right, I have a hypothetical right of action. Is this, in point of fact, connected with that? And the answers are, as I have suggested, the ones I offered his lordship a moment or two ago. But in the present case, and when we are looking across at trying to work out a line, as my Lord Neuberger asks me to seek to assist their lordships in doing, as to how this is to be determined for cases as a whole, not simply the facts and circumstances of this individual one, then the suggestion I make is that there isn't any class of case that one can sit and say this is covered by for financial reasons or any of the other ones, and it is a matter of looking to the ordinary English meaning of using loss, injury or damage, which leads my Lord Reid to ask me, well, can I help any further with those words?
Okay. Anything else?
If my Lord will give me a moment or two, I shall give him an answer to that question.
Thank you.
I'm inclined to think the answer is no, but if I may, I will just check.
Of course. Yeah, we've asked you quite a lot, so do take your time to make sure you've covered everything you want.
No, my lords, apart from my learned junior points out to me that perhaps an answer I could have offered to my Lord Mance additionally is that one of the things that it might be useful for me to know in being able to tell whether I have suffered a loss in relation to the notices to quit is, of course, whether those notices achieve the purpose for which I paid for them, which is, of course, the unhappy discovery I make at the end of 2008 when I discover that, as I say, contrary to the advice I've been given, they won't. Beyond that, my lords, it's perhaps one of the advantages of addressing much the same bench as determined Morrison that I don't need to take them through the ins and outs of Morrison, with my apologies to my Lord Mance, who gets rather left out on this.
Well, I've read it.
And therefore, I'm sure his lordship has, and therefore it would appear to me with respect that I have probably put up in my written case and the submission I've made the answer I would make to the case that's presented against me on the pleadings and in my learned friend's statement of case. Perhaps the one thing I haven't covered is he says that I make use of the words loss, injury and damage in two different senses in relation to 11.1 and 11.3. My submission, if it's not already apparent, that is, well, no, I don't. All I do is apply them differently for different circumstances. In 11.3, I'm interested in not what the actual position was with hindsight, but as the position as it was apparent to, or should have been apparent to, the pursuer at the material time. As far as 11.3 are concerned, matters known only to God are for Westminster Abbey, not for section 11.3. My lords, unless there is any further matter which they consider I could be of assistance to them, I would renew the motion I made at the outset, my lords.
Thank you, Mr. Hay. Mr. Sutherland.
I have nothing further to add,
Thank you very much. We will go out and consider where we've got to. We'll come back quite shortly, but the court's adjourned for the moment. Ms. Johnson, there are two points which really we'd like to hear you on. The first is this question of need for expenditure, the question of expenditure. And the second is the fact that we've heard there are a lot of cases that may turn on what we say, and whether there's anything you'd like to say in connection with that, given that one of the reasons cases come here is so that we lay down the law in a way that assists.
Well, if I could take that second point first.
Certainly.
I'm not able to give any statistics about the number of cases. The point I would make, which is really to do little more than adopt some remarks Miller made earlier, is that probably the last thing one needs in an area in which certainty is important is to have the relevant test under the prescription legislation constantly tweaked and refined, because all one risks doing is generating more cases which may raise different problems that are not currently anticipated. So I don't know if that helps, but Lord, I'm not sure there's really much more I can say on the question of,
keep it
of
short
other cases.
is the moral, is it? You want a strong and simple test.
Strong and simple. Yes,
Strong
I mean,
and stable test.
Yes. Indeed, yes, rather than the opposite. I forget what the opposite is. Weak and vacillating or something. Yeah. But yes, so I'll keep it short, as suggested. I think my Lord's other question
Good advice to everybody, I think. Yeah.
Was about the meaning of loss, and if I could just, the point as I understood it is and Lord Reid asked, what is the definition of loss? The case for the respondent already criticises the vagueness of the appellant's description rather than definition of loss. The points, if I could just add one or two about how I would suggest that the court should interpret loss is, yes. The first thing to note is that what the appellants are doing is suing for all the loss that arose from the breach of contract, including legal expenses, loss of the development value, and so forth. So when we then turn to the prescription legislation and ask, when did that loss occur? That's the Section 11.1 question. We're interested in all of that loss. When did that occur? And it's the Dunlop and McGowan's case that makes it quite helpful. It's mentioned in the case on MS60.
Yes.
It helpfully describes the loss that one should, the way one should describe the loss that arises from a notice to quit which did not take effect when it should have, namely the inability to recover vacant possession when it should have been recovered. So whether one describes it in that way, inability to recover vacant possession on the day, or as in some of the discussion this morning, as a deficiency in the notice to quit, those are just two different ways of describing the same thing.
Well, they're not, are they? Because the deficiency in the notice to quit, like a conveyancing error, could be said to, the damage could occur the date the notice to quit is served.
I suppose that's a fair point, my lord. The way our case proceeds is really, it puts the case in the way in which I would wish to put it, namely that the loss occurs when vacant possession is not recovered on the date on which it should have been.
Yes, it seems more attractive.
Yes.
Because the only thing that you don't know at that stage is whether the tenant is staying on simply because he's being obdurate or because there's something wrong with the notice to quit.
My lord, yes.
And that is a causation factor such as was rejected in Morrison.
My lord, that's precisely the point I would take, yes.
Yes, I mean, the only problem is that if you've got a defective title property, your loss is the date you acquire the property. It might be said, therefore, that the defect in the notice to quit takes effect from the date the notice to quit is served.
That doesn't necessarily, I suppose, lead to a loss in the sense that the defect may not be noticed or it may be waived, and it might be said that it's not clear, it's not inevitable. I mean, the tenant might leave, die, or whatever, move.
My lord, yes. I think that's why, as my lords may have seen at a previous stage, well, only in the outer house, in fact, at a previous stage, an argument was put forward that one could reasonably say that the loss occurred on the date the notice, which was defective, was drafted. But I think for precisely the reasons my lord gives, it's much more attractive to say that the loss arose when the tenant did not actually remove.
Certainly more attractive, but on the other hand, the defect in the conveyance might not appear in the sense that when you come to sell on, a purchaser mightn't notice.
Yes.
But I can see there's a difference in the notice to quit. You're expecting something to happen on a certain date as a result, whereas with a conveyance, you're getting a property which is immediately devalued. But yeah,
Yes. And
these fine distinctions sometimes have to be made, but you're inviting us not to make fine distinctions in this case.
my lord, that's right. I'm inviting one really to take the view that they could see that something had gone wrong on the 10th of November 2005. As my lord Sumption says, to require them to know why it had gone wrong is to go too far, because it runs into precisely the interpretation that Morrison set out. For what it may be worth, it was a matter of agreement. One of the matters agreed in the joint minute of admissions refers to a very good reason why the tenants might not have moved out. If I could simply give the reference, it's MS 187.
Thank you.
Paragraph 28.
Yes. Yes, I see.
And my lords will see there that this is the tenant's solicitors writing to the defenders and informing them that they have the opinion of senior counsel, who considers that the right of occupation does not rely on the leases in respect of which the notices were served. If, as counsel advises, our client is in a secure position, the termination of these leases is not relevant. So my lords have there, at the very least, an indication that there should have been no cause for surprise that the tenants did not go in November. Senior counsel's advice had been taken, which was to the effect these notices will not work.
Yes.
My lord, I think the only other point perhaps I might add it relates to the statutory interpretation of section 11 and 1 and 3.
Yes.
And I think it's fair to say, I've described what section 11.1 does. One looks for the loss and one identifies when did that loss occur. And as we've discussed in my submission, that's the 10th of November 2005. Now, because of the way section 11 is drafted, we have to look at exactly the same loss when we get on to section 11.3. It's the same loss as we have in section 11.1. The only difference is the date. And where, in my submission, the appellants go wrong is by shifting the meaning of loss, injury, and damage between the two subsections. So when they get to 11.3, they're no longer looking at the whole loss. They're simply looking at the loss of which they were aware. And it's my argument, which is already anticipated in the case, that in effect what they're saying is that an item only becomes loss once they know it is loss. Now that is plainly not how the Act is meant to work. It doesn't become loss when they know it's loss. The way the Act works is that the loss in both subsections is the same, and in section 11.3 one is simply looking for awareness of that same loss. And I hope what I said at the beginning about recovery of vacant possession sufficiently addresses my Lord Neuberger's question about how I would characterise the meaning of loss. And perhaps just a final point is that doing the characterisation in that way avoids many of the issues which we were discussed with my learned friend this morning, that one doesn't need to worry about whether an expense incurred is known to be a loss. One is looking at the wider question, what was the loss, one head of which is the expenses, but one's not looking at the expenses just for themselves. Well, I don't know if that answers the points that I was asked to address, but those are the only points I would wish to make in amplification of the written case.
Anything else? Thank you. Thank you very much.
What about Lord Hodges' fan?
Sitting in the back of the court, or?
I'm not sure I find, with respect to Lord Hodge, I'm not sure I find the analogy of the fan the most helpful way of trying to understand the question that's before the court here.
So he put the fan back in his box.
Yes.
But I mean, would you say that the loss is suffered, you've got defective goods, even if you don't open the box for 7 years?
I suppose if the goods are defective, then you have, yes.
Yeah.
And then if one wants, one of the examples figured was how did the problem
arise?
Well, when it was first switched on, it worked for a couple of minutes, okay. But then again, as Lord Sumption pointed out, we can't allow ourselves to be distracted by alternative causes and require knowledge of which was the actual cause, because that's precisely...
The point about the fan in the box is that they know they are ignorant of more than just the cause. All they know is that they've paid out some money. What they don't yet know until they open the box is that they haven't got the quid pro quo that they expected, and it's only when they realise that that they know that there's a loss. It's a further question whether and at what stage they know what the cause of that loss was.
Yes. Lord, I would respectfully agree with that. One takes it in stages. First the loss, second any further questions.
I mean, and if the box had contained not a fan, but a stone, you'd still have suffered a loss when you bought it, and the fact that you didn't open it for 7 years is different.
Yeah, but you wouldn't have known of the loss. You wouldn't have known of the loss.
The loss had been suffered, but you wouldn't yet know.
Quite.
But you couldn't, if you'd bumped into somebody and dropped it, you couldn't say it was, you didn't know, because you wouldn't know who caused it. That's the point.
I suppose that's where this section 11.1 and 11.3 point comes in, that for 11.1 there is a loss because what's in the box is not what ought to be in the box. Yeah. But for 11.3 there isn't, because we don't know what's in the box.
Sounds a bit like Schrodinger's cat. Yes.
Yes, I know. And I'm with you.
Good. Or maybe it's Heisenberg's uncertainty principle, anyway. Yep.
I'd rather not make any submissions on that, if that's acceptable to the court.
Good. Thank you very much. Mr. McKinley.
My Lords, I have nothing to add.
Mr. Howie.
I don't conceive there is very much that I should add. The Lordships were asking questions of my learned friend. I would venture the suggestion that the reason that there was the concentration on fees is because it was apprehended that that was probably the first bit, or clearly an early bit, which was well outside the period of prescription, and would therefore be a sort of simple answer to that. It may not, of course, be quite sufficient for their Lordships' views of, on a more general basis, as to where the law general terms goes. Beyond that, Lord, I don't believe my friend said anything which was beyond the bounds of his case and which I've got a right to say anything more about.
Thank you very much indeed. Well, thank you both for your oral submissions, particularly Mr. High for your full submissions. And thank you also to all those involved in the preparation of the printed cases, the written cases. We will consider this matter and let you know our decision in due course. Thank you all very much indeed. Court's now adjourned.